To make sure the record accurately reflects what the request was from Mr. Greco, I did request number one, the factual evidence jurisdiction, and what he's using as a charging instrument to prove.
I gave you Mr. Greco.
Yes.
Mr. Lanto would like to. He's not going with any House counsel. He is wishing to represent himself. So today's the date and time set for the arraignment pretrial. He is in prosecutor room 1.
Okay. All right. Very good. I'll be there.
Yeah. I'll be there. Mr. People versus Lanto.
Your Honor, David Greco here on behalf of the city of Taylor.
And Mr. Lanto, your name for the record, please.
Well, I'm here in a conference room. Can I just come into the court?
If you'd like to, yeah, sure.
Okay, let's do this.
I'm bringing the recording up here.
Hello.
Morning. Good morning.
Morning. First, I'd like to recall the case of City of Taylor versus Joshua Lanto, case number 2022-22-2024-OM-OM. That case was dismissed without prejudice, which is against my wishes, and which is why I chose to speak for myself in the court of law today. Just let me know when you're ready.
Yeah,
Appreciate that.
on the technical. I prefer everything to just be in person, just old school look. Not my call. All right, so let's get back to what I was doing. Case 230877 OM People versus Lanto. Mr. Greco, you already placed your appearance. Sir, your name for the record, please.
Joshua Lanto.
All right. So today is the date and time set for an arraignment and pretrial in this matter. First off, as to the arraignment, sir, you do have the right to remain silent. Anything you say can and will be used against you at trial. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the court of public expense. Do you understand those rights?
I understand the rights that you just told me.
All right. Sir, are you choosing? I do have a court-appointed attorney here. Are you choosing to represent yourself today?
I am choosing to speak for myself.
Well, let's just represent, speak.
I mean, in legally.
Tomato, tomato.
Yeah,
So-
no, you can't represent.
No, just at any point, if you do wish to have a court-appointed attorney, please let the court know so that I can effectuate that right in your wishes with regard to it.
I appreciate that.
Now, with regard to the alleged charges in this matter, it is alleged that with regard to the arraignment, do you wish me to read the complaint, or would you like to waive the formal reading?
If you'd like to read it into the record, I'd appreciate that.
Sure. Okay. All right. It is alleged. It is alleged that on November 17th of 2022, that you, in count 1, that you violated City Ordinance 32-31, commonly known as interfering with the police authority. That's a misdemeanor punishable by 93 days in jail and or up to $500 in fines. In count 2, it is alleged that you violated City Ordinance 32-31, interfering with the police authority. Again, that's a misdemeanor punishable by 93 days in jail and or up to $500 in fine. In count 3, it is alleged that you violated City Ordinance 32-31, commonly known as interfering with police authority. And again, that's a misdemeanor punishable by 93 days in jail and or up to $500 in fines. As to those charges, how do you plead?
Well, I'm not prepared to make a plea at this time.
And I'll recognize you as standing mute, and I'll enter a plea of not guilty on your behalf.
Well, if I could just object to that for just a moment. Because you did say, which is why I was trying to recall the matter of City versus Taylor versus Joshua Lanto in the previous case, because you said in that arraignment that I have the right to be informed of the cause and nature of the charges, correct?
Mm-hmm.
Okay, so obviously that case got...
Did you get a copy of the complaint? Are you talking about in this matter?
No. I haven't seen anything. As a matter of fact, I've requested discovery from your House counsel several times, and they have not given it to me.
But this case hasn't even started yet. This case is just getting
right. So the case.
It's at the arraignment stage. Right?
Yeah. So the case that I wanted to recall, because I had the right to be informed of the cause and nature of the charges in that case, but it's clear
that's not the case that's on my docket.
But that's why I wanted to recall that case, because this stems from the same incident. So it's almost
You're
like.
saying recall is because there's two different meanings of the word recall. Recall is to remember, or recall is to actually call that case.
I would actually like to call that case because it was dismissed without prejudice, and I wanted to be dismissed with prejudice. And I made it clear to House Counsel that I had expenses when it came to that case.
Okay.
I think it's only fair.
So just from a procedural standpoint, it's not on the docket today. Due and timely notice wasn't given to the court nor to Mr. Greco about your desire to do anything with that case. So you need to motion that up for a motion.
But we are on record, right?
But we are on the record,
Okay.
and let the record reflect that I'm telling you that procedurally you need to, if you have anything you want to do with some other case that isn't the case that's set for this docket today,
Yeah.
file a motion, file it with whoever you're going to serve obviously the other side, serve a copy on the court. The court will set it for a motion date.
Yeah, I appreciate
Then
that.
that case will be brought, and then everybody will be knowingly and voluntarily present, and they will be given all the notice ahead of time of what it is you want to do.
Okay, well, I appreciate that, and that actually speaks to the arraignment that we're doing here right now.
This is a different situation. The arraignment today is just simply, I'm telling you what your charges are. I'm telling you what your constitutional rights are with regard to an arraignment. Then I'm asking either for, how do you plead? You can either plead guilty, not guilty, or you cannot answer that question, in which case the court will automatically enter recognize you as standing mute and enter a plea of not guilty on your behalf, so that it preserves your not guilty status and it preserves your constitutional rights.
And one of those constitutional rights that you explained to me is that I have the right to be informed of the cause and nature of the charges. And my point.
That's correct, and that's why I just told you that you were, count one is alleged that you violated City Ordinance 32-31, commonly known with interfering with police authority. Now, if you'd like me to read the expanded complaint, I can read the expanded complaint to you.
Well, may I just speak without being interrupted for a minute?
First off, I'm not interrupting you. Second, I'm just making sure that things are procedurally done correct. Third, I'm going to advise you that anything you say can and will be used against you. You do have a right to remain silent.
I understand.
So if you choose to say anything.
Well, the reason I'm asking questions about the cause and the nature of the charges is because on the last case that got dismissed, it was clear
You
that
got to stop referencing the last case, because that's a separate case. Whatever happened with
we
that
have the
case,
same thing going on in
that
this
case.
We have a similar situation in this case, whereas I don't know if the prosecutor understands the cause and the nature of the charges because he had to dismiss the last case.
Yeah.
Right?
Well,
So
I'm about to then let me read the complaint to you.
Okay.
Let me make sure you get a copy of the complaint.
Right.
So,
And I saw your YouTube channel I saw your video on YouTube. where
first
you
off, it's
explained-
not my YouTube channel. It's
Well,
something that's forced upon me
yeah.
that I'm required to do because there's a court order signed by my chief judge. I prefer to do all my cases in person, but I'm required to broadcast them live because.
Well, I certainly appreciate any government entity willing to use transparency to put
Oh,
the truth on the table.
I'm
Is 100% on the favor for it because
I don't have anything to hide. I don't do anything wrong. I don't have any.
You did explain
nefarious
factual
features.
evidence of jurisdiction, though, and you did explain it for about the better part of a half hour to a guy. Last time I was on
Because
Zoom, I was
what?
told I was crazy for
Didn't-
talking like that.
You didn't understand me, so.
Right, but I was told I was talking crazy for asking for it.
No, not at all.
Okay, so I'm not crazy. Okay, that's
You
first and
can
foremost.
always challenge jurisdiction. Jurisdiction is something you can even challenge for the first time on appeal. One of the only things you can challenge for the first time on appeal.
Well, luckily
So-
we have about 160 people watching this right now that have heard that for the first time that probably don't understand that.
I get it. A lot of people watch a couple of things on YouTube or a couple of things on Google, and they think they become a legal scholar.
Well, let's be honest, they watch Law and Order and then they think they're experts on the law.
I can't watch them.
Me neither.
I should.
It's actually painful to watch that sort of stuff,
It's entertainment. That's exactly
It
what
is. It's meant for entertainment.
It's not.
right? On the last case that was here though, I just have a few other clarifications. I need
Listen,
to make.
again, I'm not going to discuss on the record any other cases that are no longer.
No, this isn't in regards to another case. This is in regards to my case and what happened.
This case right here.
Yeah, in this case, right, yeah.
Again, before you start discussing the facts of this case, I am going to caution you that you have the right
Fifth
to
Amendment,
sign
yeah.
it.
And I don't sign anything, so I'm just.
That's a copy of the.
Okay, appreciate that. And now is there?
So now I'm going to read into the record what the allegations are.
Okay?
All right, so it is alleged that on November the 17th, 2022, that you violated city ordinance, chapter 32, article 2, section 32-31, interfering with police authority, which states, it shall be unlawful for any person within the city to resist any police officer, any member of the police department, or any person duly empowered with police authority while in the discharge or apparent discharge of their police authority duty, or in any way to interfere with or hinder the police officer or member of the police department in the discharge of the police authority duty.
And just a quick objection, just a point of clarification.
There's no objection to that because that's just that is the ordinance.
Okay, if you're just reading it into the record, I understand.
I don't the ordinance. That's
yeah, I just want to know what in any way in this chart. What does in any way?
Again, I can't answer that question because for me to answer that question would be me giving you legal advice. If you want to file a motion, you can more than welcome to file a motion.
Yeah, because in any way seems awfully vague and it seems obtuse and it seems like it's just
these are all great things that somebody might want to argue in a motion.
Yeah, it seems impossible to determine what in any way.
So, but if you could, please don't interrupt me until I get down to the bottom here because I want to let you know exactly what the allegations are against you from a factual basis. These are the reasons that the warrant was signed, because I found that there was probable cause that a crime was committed and probable cause that you were the one who committed the crime, hence why the warrant was placed into existence in the first place. It is alleged that on the above listed date, which was the 11/17 of 22, at approximately 2:50 p.m., you, the defendant, Mr. Lanto, engaged in a repeated course of conduct to interfere with Officer Andrew Borg's discharge of his authorized duties, which include traffic enforcement on South Telegraph Road near Ecorse Road in the city of Taylor. You, Mr. Lantos, allegedly had unlawful actions, including following Officer Borg on multiple traffic stops, approaching the traffic stops in the close proximity to Officer Borg and his vehicle and the drivers, yelling obscenities and insults at Officer Borg, and video recording Officer Borg while inside of his patrol vehicle while he was accessing protected lien information concerning the drivers that were pulled over. It's also alleged, Mr. Lanto, you were ultimately arrested after Officer David Jones witnessed you walking within close proximity to Officer Borg's vehicle during a traffic stop and attempting to video record Officer Borg while he was inside his patrol vehicle accessing lien information about the driver. In count one, more specifically, in count one, the violation of section 32-31, interfering with the police authority, you, Mr. Lanto, the defendant, allegedly approached the traffic stop at approximately 3:04 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol vehicle, and the pulled over driver in the center median of Telegraph Road and yelling and hurling insults and obscenities while Officer Borg was discharging his police authority duty. In count two, violation of section 32-31, interfering with the police authority, you, the defendant, Mr. Lanto, allegedly approached the traffic stop at approximately 3:12 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol vehicle, his patrol car, and the pulled over driver, the parking lot of the Tropical Smoothie Cafe, and yelling and hurling insults and obscenities while Officer Borg was discharging his police authority duty. In count three, it is alleged a violation of section 32-31, interfering with a police officer, and that you, the defendant, Mr. Lanto, allegedly approached the traffic stop at approximately 3:31 p.m. and interfered with Officer Borg by being in close proximity to Officer Borg, his patrol car, and the pulled over driver in a parking lot on South Telegraph Road and attempting to video record Officer Borg while he was inside of his patrol vehicle, accessing lien information about the driver, and otherwise discharging his police authority. Again, those are misdemeanors punishable by 93 days in jail and up to $500 in fines. Those are the factual basis which gave rise to probable cause to execute this warrant, and now is being charged against you. Again, you have the right to remain silent. Again, you do have the right to have counsel at any given time. You're choosing today. As to those charges and the allegations, how do you plead? Guilty, not guilty, or you stand mute?
Well, I have to make a few clarifications before I make an informed.
This isn't a matter of clarifications. This is you either pleading guilty, not guilty, or standing mute.
Well, I was told I have the right to be informed of the cause and the nature of the charges. You just read this into the record, and all it did was confuse.
I did.
So, because we have right in here, that Officer Bo, or I was told
Listen,
it
I'm
was
not-
close proximity of
Sure.
Officer Gore.
I'm not
What
going to
is-
get
what
into
is
the
close
particulars.
proximity?
Listen, I'm not going to get into the particulars. This isn't the trial. This is, nobody's sworn in under oath. There's a subject to cross-examination by both sides. That's what trials are for.
Okay,
That's what trials are for.
before I make
This
an
is
informed,
just these things. So I'm going to give you 5 seconds to either choose guilty, not guilty, or just don't say anything. Or if you're not responsive, then I'll just enter a plea of not guilty so that your not guilty status is preserved and your constitutional rights preserved there as well.
well,
So how do you plead? Guilty, not guilty?
I object for clarification.
Sure. Guilty or not guilty?
Well, I object to that because I can't make an informed plea today.
All right, then
Unless I have
enter a plea of
discovery.
not guilty on your behalf. So you're still not guilty on your behalf, and they have the
Well,
right
and
to.
then, just let the record show I do not want a plea being made for me. Just, you understand why I have to
There's
say that on the record.
there's no choice in the matter. I'm procedurally required to move forward by doing one of the three. So,
Well, I was told when it pertains to this case at the last proceeding that was here, and I don't know who you had stand in for you.
I don't pick.
As a bald guy, you look like a mob boss.
Don't know. My father passed away. I had to not be here, so.
Yeah, and he ordered me in here in person, said he was gonna have somebody watch over me, which sounded like a veiled
No, no.
threat.
So again, I wasn't here. I wasn't presiding over that case at the time.
Well, if it's true that he did that, would you perceive that as a veiled threat?
I'm not gonna answer that question, sir, because it's not the time nor the
Yeah.
place for it. No one's been given any due
Well,
time
this-
notice of anybody, and nobody's been advised in the premises of any of that information, so, again.
Well, I have the video if you'd like to watch it. He ordered me in here in person, said he was gonna
Today's
have.
the date time set for an arraignment.
Yeah,
Today's the date and time set for the arraignment.
well, I'm just saying,
That's all we're doing today is the arraignment, and it's also set for a pretrial. So you have the opportunity to speak now, that you've been advised in the premises of what you've been charged with. I've entered a plea of not guilty for you. Would you like to speak with Mr. Greco about any potential resolution?
there were a few key things
Would
that
you
were
like to
said.
speak with Mr. Greco about any potential resolution?
Well, can I just make a clarification on the record?
I don't know what more you're going to clarify. Today's purpose of today is for me to inform you of what you've been charged with.
I
I have
understand,
done that.
I
And
understand,
now
but
I
when you
have
had
other
that,
cases that I need to get to. This is why cases are scheduled in certain ways and with
well, I'd be
regard
happy to be
certain
the last
stuff.
case called today, so we
So,
can
what's that?
properly, clarify a couple things. I'd be happy to be the last case called, so we can properly clarify a few
Well,
things.
first off, there's nothing to clarify. I've told
But
you
there
what
are.
I've been charged with. There's not. So I'm going to ask you right now to either talk with Mr. Greco and have a pretrial discussion with him. You're more than welcome to do that.
Could I just tell you what was
Your
said
Honor,
on the record?
Your Honor,
The last case,
The last
in
proceeding,
regards to this case.
in regards to this case, because this is the first time I've seen
The
it.
judge said on the record that he was powerless to make Mr. Greco provide anything regarding factual evidence jurisdiction.
Until the arraignment kicks in, yes, they're not going to be, because the case doesn't start until it's actually you've been told what you're being charged with.
Right, because he said he can't make him produce the factual evidence jurisdiction. That's what the judge said at the last.
I wasn't there and I wasn't the judge. What I'm telling you is this. I have told you exactly what you're being charged with.
Okay.
There is an order in here for discovery. If you want an order for discovery, if you want to get a chance to have discovery, absolutely. If there's anything that's out there discoverable, then you have every right to go and get it in preparation for trial.
Well, let's do
But
that.
that's
Let's
not
move
today.
this forward because
That's not
I have a
today.
feeling. I have a feeling I need to inform you of a few things that pertain to your police department here, and I actually.
First off, if it has to do with the case, I can't take in anything from outside of the case. There's a reason that hearsay is not part of cases. Why? Because they're literally by definition an out-of-court statement being used to prove the truth of the matter asserted under Rule of Evidence 801.
Well, you've
That's
got
literally the
officers that are
definition.
lying.
So if
Yeah.
so if you're telling me stuff right now, one, you're not under oath, so I could care less. Two, this isn't the trial.
Would you like to put me under oath?
No, I want to set this up for, if you want a trial, I'll give you a trial. That's what I'm
If
saying.
you want to see what happened.
And again, all of that would be done at a trial. If you're going to bring in evidence, it has to have foundations. You have to lay a foundation for every piece of evidence.
Well, then.
Evidence doesn't just come in. It has to be factually accurate and it has to be reliable.
Okay,
If they're
so.
not both, that's how you lay a foundation for evidence. I have a scale in my garage. Every time I get on it, it says I weigh 187 pounds. I love that scale. Mwah. It's very reliable. Every time, 187. Mwah. Guess what? The scale's not accurate. It's reliable, but it's not accurate. All evidence has to, and that's what we do at trial. Today is just the day when I'm telling you this is what you're facing. This is what they are alleging that you did. And if you'd like to set it for a trial, you can do so. If you'd like to have the assistance of an attorney, I'll make sure you have an attorney present with you. Even if you just want them riding shotgun with you, so you can ask questions about the rules of evidence and things like that. I'm not sure what I don't know if you have.
Well, that's the only reason I would ask for counsel.
I don't know if you have a Juris Doctorate. I don't know what you know. I don't know what you studied. And I'm just telling you, that's why you have a right to assistance of counsel. Okay. If you'd like it at any time from now until the trial.
For administrative purposes only, but I will speak for myself in the court of law. I do not want anybody speaking for me.
Sure.
And they did that for me up in Pontiac. They gave me standby counsel.
Again, you're talking about some kind of case that I have nothing to do with.
I'm just wondering.
And trust me, while I appreciate it, I don't need any examples because I teach all of this stuff. I know exactly every example.
So, and I'm pretty sure you know what Houston still says about police interference.
So, again, if you want an attorney, I'm going to let you have an attorney. If you don't want an attorney, you want to speak for yourself and represent yourself, you have a God-given constitutional right to represent yourself. Houston still says that police interference is physical. I'm not going to get into a civil procedure class here. I have other cases to do. You've been advised in the premises of what the charges are against you. I'm finding you're unresponsive as to guilty or not guilty, so I am going to put in a plea of not guilty.
And I have to object to that on the record.
Sure, it's on the record. And now, if you don't want to speak with Mr. Greco at this time, then you're more than welcome to leave, and you'll be given a notice as to moving forward. I can set this up for a settlement conference, or we can just set it directly for a trial.
Okay, and then the next time we're here, we'll be able to recall the old matter, so I can get reimbursed.
I can't answer that question because that may be me giving you legal advice.
Okay.
When I'm wearing this robe, it's like being a referee. I can throw a flag, blow a whistle, but I can't coach either team.
Yeah.
I can't tell you how to proceed or what manner you should proceed.
Well, you spent about a half hour explaining it to somebody else.
No, I explained to them.
Well, it was a formal motion.
I wasn't giving them legal advice. I was merely explaining what jurisdiction means. They had already said in their motion, they had filed a motion. Right. Stating each individual reason.
I watched it. I pay attention. I'm actually here to look for areas we can find agreement.
Say again, I'm sorry?
I'm actually here to look for areas we can find agreement.
Oh, well, then that's someone you need to talk to Mr. Greco about.
Well, I don't think he's going to find agreement.
Well, you're not going to find. With me, agreement comes from because the two parties approach me with an agreeable situation that they want to put on the record in the form of a plea or a dismissal, or I do a trial and I let the facts that are all under oath speak for themselves.
Well, and when I saw the mob boss judge, he actually had a different case, and he was actually a lot more fair than I originally gave him credit for. So the mob boss judge, I'm glad he's not here, but he's the one that told me I would be assigned an army.
Well, first off, I don't find I find it disrespectful to refer to somebody as a mob boss. That's because that literally.
That's how it felt to me.
Well, what I'm saying is you just libeled somebody.
Well, that's how it felt to me.
Because now you put him in what's known as false light. And I'm just telling you, I wouldn't do that.
Well, I appreciate
for civil reasons alone, I wouldn't do that.
I appreciate the warning.
But, and I'm not going to allow any sort of disrespect to the judiciary, especially when I didn't watch over it, and especially because the Judicial Tenure Commission, if they sanctioned the action, then sure, I have no problem with making commentary about it. Until that's been done. There's no need for doing that.
Yeah.
And trust me, you're not going to garner any favor, nor are you going to do anything but lose respect from me if you're just going to throw like petty comments in there like that. I prefer people who just let the facts speak for themselves and let the law speak for them, and they just keep it professional.
Okay, well, as long as we're just here to put facts on the table, I can do that.
Sure. Then you've been advised, and so you are either free to go or free to talk to Mr. Greco further.
All right. I mean, if he wants to talk to me, we can talk.
All right, Mr. I can always. You can sign back in, or Mr. Greco, are you available to talk any further today on this case?
Your Honor, Mr. Lanto and I have spoken, and it's either going to be set for a settlement conference, and we can provide him some of the discovery information with the order, or a trial. That's for us to talk about anymore.
So I was getting the discovery regardless.
You haven't asked for discovery, but when
I asked Mr. Greco in the
he's going to get it regardless. It's just what is set for.
So what I'm going to do is I'm going to set this for a settlement conference. You'll be given the date in the mail of when that settlement conference is. Mr. Greco, if there's any discoverables, type discovery, make sure you send that to Mr. Lanto. Mr. Lanto, did you provide Mr. Greco with an email and a phone number?
He's got my email. He's got my email. And then just to make sure the record accurately reflects what the request was from Mr. Greco. I did request, number one, the factual evidence of jurisdiction and what he's using as a charging instrument to prove.
I gave you a copy of the charging instrument, the warrant.
Yeah.
The warrant
But it does nothing to explain jurisdiction. You went over it for a half hour with somebody else. That's not on you.
That's.
Your Honor, I'm going to provide Mr. Lanto with the discovery we have. I'm going to move on to the next case.
All right. So you'll be getting the date in the mail of when that is, and if there's any issues as far as discovery or anything else, that's why the court rules provide for motion procedure.
Yeah, because at this time in the record, I'm not voluntarily surrendering jurisdiction. Fair?
Duly noted.
Fair? Okay, thank you.
Noted.
All right.
All right. Have a good rest of your day. Have a good rest of your day, sir.
Things heat up when the defendant calls the previous judge a mob boss. The judge immediately warns him about disrespect and tells him to stick to the facts and law. But the defendant still challenges the court's jurisdiction. Like, subscribe, and we'll see you in the next video.